Here for the public board meeting. Mr. Terrell, Mr.
My name is Christopher Miley from the Attorney General's Office, representing defendant Evelyn Gong.
And Mr. Taylor, good morning.
Morning.
All right. So we have here two motions. One is a motion to dismiss. That's by the defendant. And we have a motion for summary judgment, and that's by the plaintiff. Is that correct, plaintiff?
Yes.
All right. Is that correct, defendant?
Yes, Your Honor.
All right. Now, where are we with the motion to dismiss? That one was filed first.
Correct. So that motion to dismiss is adjourned, I believe, in February, the time for the defendant to submit a reply. He has since done so. So it is the defendant's position that it's ready for submission.
All right. And Mr. Taylor, you did file opposition, is that correct?
Yes.
All right. So I do see that here in the court's record. So we have the opposition, and then I do see we have the reply.
I want to make the court aware of something.
All right, go ahead.
So, I made the judge that was on the bench aware last time I was here. I'm going to just make you aware again. Make the court aware that there was a notice of motion filed on January 9th, 2026, but I was never served with that notice of motion. I was served with an amended notice of motion that was filed January 21st, 2026. And that was a tactic so that I wouldn't file a timely answer, because you can only file an opposition to a motion if you're notified of the motion. I was never notified of it. So this is actually fraud by the defendant to serve me, excuse me, to serve me with an amended notice of motion, but not the original motion, is fraud. And that was done so that I couldn't file a timely answer. Because if, like I said, if one is filed January 9th, which was the original motion, and I was never notified, then an amended was filed January 21st, that's taken away from the time that I have to file an answer. And so, as far as I'm concerned, the court shouldn't even entertain this the notice of motion. They shouldn't even entertain it. And this is why I filed a summary judgment motion. Because the fraud that the defendant is committing is wasting the court's time and wasting my time. And this is a important issue here dealing with my driver's license. I used to work for Amazon as a delivery driver. I'm trying to go back to work. This is messing up my livelihood, and this is just wasting time. I need my driver's license to be reinstated. So, this, and there's no question of fact regarding this case. This case does not need to go to trial, and this is why I filed a summary judgment motion. In addition to the tactics that the defendant is committing, which is fraud. Your Honor, you can't expect me to file an opposition to a motion that was never served on me, and then after that, you've served me with an amended notice of motion. That's fraud.
If I may, Your Honor.
Go ahead.
So I believe defendant's reply affirmation to the motion, paragraph 6, sets forth the timeline. It also attaches as exhibits the affidavits of service for both the original notice of motion with the affirmation and supporting exhibits, as well as the amended notice of motion. I believe the affirmation sets forth, but I could be wrong. The only difference between the notice of motion and the amended notice of motion was adding the part number. All of the documents were served on plaintiff. I can assure the court that this is not tactic. There was no fraud in first serving the notice of motion and subsequently serving an amended notice of motion. I will note that when we served the amended notice of motion, we did not attach the affirmation and supporting exhibits. Maybe that was an error, but we did subsequently make sure that plaintiff did receive all the documents at the prior hearing, and we did serve complementary papers of the amended notice of motion, the supporting affidavit, and exhibits.
Real quick, Your Honor, real quick. This further proves that there was fraud going on. So I'm stating that I was never served with a notice of motion. I never got it in the mail, so you know that's one thing. I guess it can't be proven, but why would you serve me with an amended notice of motion that doesn't comply with CPLR 2214? There was never an affirmation or affidavit in support of the motion. Why would you do that? And then another thing that clearly shows that this is fraud is the amended notice of motion is not a part of the case summary, but the notice of motion is a part of the case summary. So you could clearly see there's a bunch of inconsistencies here in regards to the original motion. I've never received it in the mail. I never received it. But I did receive an amended notice of motion that was not followed by affirmation or affidavit in support. And as an attorney or whoever the defendant is, they should know that any motions has to be followed by affirmation or affidavit in support. So, you know, this is a complete fraud. But even if you entertain this motion, I would ask that, you rule in my favor regarding my summary judgment motion. Because this notice of motion is saying the court doesn't have jurisdiction, which the court does. The court has jurisdiction over a mayoral agency, which is the New York State Department of Motor Vehicles. The court has personal jurisdiction and subject matter jurisdiction. So the motion is frivolous and baseless, but it wasn't even served on me. And, so I just want the summary judgment motion to be entertained because technically there was never an answer filed in this case. And I could care less about a default. I just want my summary judgment motion to be to go before the court. Because when you really look at it, Your Honor, there was no answer. The notice of motion wasn't filed on me. The amended motion wasn't filed correctly, so it was fatally defective. So there's no answer, technically,
If I may, Your Honor. Turning to the merits of our motion to dismiss, it is the defendant's position that this court does not have jurisdiction over the New York State Department of Motor Vehicles. Plaintiff just said that it was a mayoral agency. That's incorrect. It is a state agency. As a state agency, it is entitled to sovereign immunity. The New York State legislature has waived sovereign immunity, but only in the court of claims. There's case law supporting that state agencies can only be sued for claims of monetary damages in the court of claims. The defendant's position is that would be the correct jurisdiction for a case seeking monetary damages against the New York State Department of Motor Vehicles, setting aside the actual merits of his claim.
Your Honor, real quick, when you go to file a summons and complaint, there's a list of defendants that could be named in a lawsuit. And the Department of Motor Vehicles is one of them. It's right on the paper in this court building, room 357. Any agency that has a department in front of it, more than likely, that's a mayoral agency. Department of Education, Department of Motor Vehicles, Department of Finance, the list goes on and on. And all of these names is on the paperwork upstairs where you file your summons and complaint. It says that you can put the New York State Department of Motor Vehicles as a defendant in a lawsuit. So I don't know what the defendant is talking about. The court has personal jurisdiction, the court has subject matter jurisdiction.
Alright, so do you have a motion filed? Do you have an opposition filed? Do you have a reply filed? To parties consent to the matter being fully briefed?
Yes, Your Honor.
Fully briefed? What does that mean exactly?
So meaning it's been fully submitted, so that the court can render a written decision in order based on those papers.
I wouldn't agree to that because the defendant has committed fraud. The defendant never served me with that notice of motion. And the defendant is sitting here lying before the court, committing perjury before the court. And even if the motion was served on me, it's baseless and frivolous, the argument. So, question, Your Honor, if I'm saying that the motion, the notice of motion never came in the mail, and the defendant is saying that it did, or the affidavit, how can we get to the bottom of that?
The court does not give legal advice, but there is a help desk here, as you know, and that help desk has resources where you can find information on the process.
A help desk? Listen, we talk about an argument that's before you right now, and I'm telling you that you hear that the defendant is saying it was an affirmation of service, committing perjury, committing fraud again, and I'm saying that it never came in the mailbox. So what I'm asking you is, you're going to tell me to go get legal help for that? We don't even have to get into it. I just wanted to ask the court, how are we going to get to the bottom of that? Because I've never received a notice of motion in the mail, never. But I did receive an amended notice of motion. I said it 5 times. I said it to the other judge, and, so, Your Honor, once again, if I'm saying I didn't receive a notice of motion in the mail, and then later on, an amended notice of motion comes in the mail that's fatally defective, is that a red flag or not? Like, so at the end of the day,
The court does not give legal advice.
I don't want legal advice.
Advice that is legal in nature.
So how?
There is a space in the courthouse where you can get more information on the legal process.
Okay, so I just want to say this and end this. You cannot entertain a motion that was never served on me. And, the opposition that I'm filing is the opposition for the amended notice of motion that was fatally defective. But they both argue the same thing. But I don't want to sit here and agree that the case be fully briefed. That's what you said? That was the wording?
All right, if you object to it, then the court realizes that you object to it. It was a question. Do you object to it? Do you consent to it?
What happens
If you
next?
object, then you object.
If you object, then what takes place? What is it, an
Well,
adjournment?
we have to talk about the other motion as well, the motion that you filed.
Oh, okay.
We're not done with the discussion,
Oh, okay.
but I did want to ask you and give you a chance to tell us whether you consent or not to the matter being fully briefed. When I say fully briefed, I'm referencing the defendant's motion to dismiss. All right? Now that we know that you do not consent to that being fully briefed, all right, we can move on to discuss the other motion, which was filed second. That is the motion for summary judgment. That is the motion that you filed.
Yes.
All right, so we have that on file. All right, we also have opposition from the defendant.
I don't believe we filed an opposition to a motion for summary judgment.
Right, because I don't have it.
Is that,
I just want to make sure I'm looking at the right document. There might be opposition to the other motion.
thank you, Your Honor.
Let me look at this item. So this opposition that I'm speaking of, actually, it is the opposition for the other motion. Mr. Taylor, you did file opposition to the other motion, right? So we have that. There is no opposition to the motion for summary judgment. And this is actually the first time on, the first court date, the first hearing for that motion, which is the motion for summary judgment that Mr. Taylor filed. All right, so defendant has not filed a motion, has not filed an opposition to that motion.
So does that that doesn't excuse the defendant from defaulting, does it? Because it's on for the first time? No answer to summary judgment motion? Can the motion be granted?
If I may, Your Honor.
Go ahead.
So, as I understand it, the motion for summary judgment was filed on March 13th. The Attorney General's office didn't receive it until March 17th, about a week ago. We have not had an opportunity yet to file an opposition, so we're here today requesting an adjournment on plaintiff's motion for summary judgment, so we can have time to file an opposition.
Your Honor, you have 7 days to file answering papers, 7 days prior to the hearing date under the CPLR. Correct?
So I do see that, the notice of motion was filed on the 17th.
What notice of motion?
The one that,
You talking about summary judgment motion?
yeah, the notice of motion, meaning the motion for summary judgment.
It was filed March 13th, 2026. Under CPLR 2214B, answering papers must be served at least 7 days before the return date. Defendant had enough time to file answering papers, and the defendant failed to do so.
If I may, Your Honor,
Go ahead.
it's a mischaracterization to say that the defendant had time when the defendant did not even receive the notice until 7 days before. Notwithstanding that, the defendant's position is that plaintiff didn't serve this with enough time for the defendant to answer when service was to be completed by mail. This is also the first time it's on. We think it's just and proper for an adjournment on plaintiff's motion for summary judgment so we can file an opposition.
So, Your Honor, real quick, so the defendant is stating that they didn't receive the motion in time. The defendant is also filing a motion with the court and not serving the defendant, the other party. This is a bunch of inconsistencies here. This motion was filed the 13th. Now we got an issue with this. Like, this is a clear pattern of perjury and fraud. This motion was filed March 13th, 2026. I don't know about when the defendant received it. I know about when it was filed. There should be an answer to this motion. It's not. So I'm asking that you grant the motion, Your Honor, in my favor, in the amount of $50,000. Please and thank you.
All right, counsel, is there anything you'd like to add?
Nothing else, Your Honor, aside from the fact that we're still pending the position that the court doesn't have subject matter jurisdiction over the matter. Notwithstanding any of these questions about service of papers, time to reply, whether or not the defendant has been time and had attached affirmation to the service. But at the end of the day, this court does not have subject matter jurisdiction over New York State and the New York State Department of Motor Vehicles. Thank you.
Real quick, Your Honor, once again, when you go upstairs, there's a paper with all the list of defendants that can be named in a lawsuit, and one of them is the New York State Department of Motor Vehicles with a bunch of others. And, you know, if the court didn't have jurisdiction, subject matter, or personal jurisdiction, then why is all this inconsistency and fraud taking place that I can clearly show? And that's about it. You know, I'm asking that you rule in my favor in the amount of $50,000 and reinstate my license, please. Thank you.
I may be able to help clarify why the New York State Department of Motor Vehicles is on
I'm
its
sorry, I
form.
can't hear you. What's the background noise?
I was just saying that maybe it will help clarify to plaintiff why New York State Department of Motor Vehicles is on some of these forms, and that's part of the purpose of Article 78 proceedings, which Mr. Taylor is well aware of. He's actually submitted two against the New York State Department of Motor Vehicles. Those proceedings are for injunctive or equitable relief. This is for monetary damages, explaining our position that this court does not have subject matter jurisdiction.
So what is that, a different argument now? Is that something?
I was just trying
Your
to
arguments are frivolous and baseless, Your Honor. Please, like, I have children, I have to work, I can't move from point A to point B, I can't do anything. All because of this fraud. Like, please, I don't have time to joke around with my license, my driver's license. This is how I work. This is how I get around. This is how I take care of my children. Like, oh my God, man, this is sad, bro. Like, it's sad, man. It really is, man. Once again, Your Honor, New York State Department of Motor Vehicles is listed on the paper upstairs with a bunch of other agencies showing you that you can sue, that you can name the defendant in a civil suit, as I did. That is in this courtroom, upstairs in room 357. This agency is one of them. The court has jurisdiction, subject matter and personal jurisdiction. And I don't have time for my license to continue to be suspended unjustifiably, fraudulently.
Thank you.
right, now, with respect to the motion to dismiss, the court reserves decision. With respect to the motion for summary judgment, the matter is adjourned in order for it to be fully briefed. All right, the clerk will provide the next available adjournment date.
All right.
Question,
Thank you, Ron.
Your Honor. Can I ask a question?
May 5th, 5/5/26.
No written decision, nothing? All right.